An Adams County couple is suing the state of Colorado, the Department of Education, and their daughter's school district.
They say all three violated their constitutional rights by encouraging their daughter to transition to a different gender without their knowledge or consent. Your political reporter Sean Boyd obtained a copy of that lawsuit, which could be precedent-setting.
At issue is a new state law that requires schools to use the preferred name and pronoun of students who are transitioning to a different gender, and a policy at 27 J schools that prevents high schools from notifying parents without a student's consent, noting in some cases telling parents puts kids at risk. But the parents who filed the lawsuit say not only should they be notified, they have a right to be notified. The parents, who go by John and Jane Doe in the lawsuit, claim their 14-year-old daughter was struggling with depression and anxiety when she turned to a counselor at Brighton High School for help, telling the counselor she had feelings of transgender identification. The counselor, they say, encouraged their daughter to begin using a non-female name and pronouns at school and receive mental health treatment through a state portal called I Matter, where they say a therapist discussed hormone therapy and a mastectomy.
It happened all in secret for months and months without our clients knowing.
Eric Sell with the Center for American Liberty says that's unconstitutional.
So what we're arguing is that parents have the constitutional right to consent and be informed of treatment that the government is providing. This isn't something that schools should be doing on an ad hoc basis at the child's direction.
The lawsuit hinges on the 14th Amendment, which, according to the complaint, protects the rights of parents to direct and control the upbringing of their children, including decisions regarding treatment that can have serious lifelong consequences, and the First Amendment, which it says protects the right of family relationships without undue interference by the state. John McHugh, an attorney who specializes in LGBTQ cases, says kids, too, have rights.
And there have been federal courts, circuit and district courts across the country that recognize that students have privacy rights. And those privacy rights include the right to keep certain information from their parents.
Particularly, he says, when it poses a risk to their health and safety. If successful, the lawsuit would impact the privacy of gender transitioning students only. McHugh says that's discrimination.
You can't have a rule that says just for transgender students, we are going to require this type of information to be disclosed, but for everybody else, we're fine with not mandatory disclosing it.
The conservative nonprofit Center for American Liberty and the Gessler Blue law firm are representing the parents, who say after seeing a private therapist, their now 16-year-old daughter regrets wanting to transition and identifies as a female again. Sean Boyd, covering Colorado First.